Welcome to this course, where we will demystify the Florida real estate exam structure and the regulatory frameworks governing licensure. By the end of this module, you will have a clear understanding of the professional standards and logistical requirements mandated by the state. This content is for informational and educational purposes only and does not constitute legal or professional real estate advice. This is an unofficial, independently produced course and is not affiliated with, endorsed by, or connected to the Florida Real Estate Commission, FREC, or the Department of Business and Professional Regulation, DBPR. Always consult with qualified legal or professional experts before making career or legal decisions. Florida real estate practice is strictly governed by Chapter 475 of the Florida Statutes, which serves as the bedrock for all laws we will encounter in this course. Understanding this chapter is not optional because it defines the limits of authorized brokerage activities and sets the rules for professional conduct. The Florida Real Estate Commission, known as the FREC, acts as the regulatory body with the power to interpret these laws and enforce administrative rules. Alongside the FREC, the Department of Business and Professional Regulation, or the DBPR, handles the administrative, executive, and investigative duties. This distinction is vital because the DBPR processes your application, but it is the FREC that holds the authority to grant or deny licensure based on its quasi-legislative and quasi-judicial functions. Mastering this relationship ensures you know exactly who is overseeing your license throughout your career. Your first step towards certification involves the Candidate Information Booklet, which acts as the official guide for the examination process. This document contains critical details regarding testing centers, prohibited items, and registration logistics that you must adhere to strictly. The examination itself is divided into two primary categories: real estate law and real estate mathematics. You should expect roughly 45 questions pertaining to license law and brokerage practices, while the mathematics portion covers financial calculations such as prorations and closing cost distributions. To pass, you must achieve a score of at least 75 out of 100 possible points on the state examination. Approaching this as a structured system, rather than a collection of random facts, will allow you to prioritize your study time based on the weight of each subject area. The application process requires careful attention to detail, especially concerning your personal history and professional background. You are required to submit an application to the DBPR, which triggers a comprehensive background check, including mandatory electronic fingerprinting. You must be prepared to disclose all criminal history, regardless of whether it resulted in a conviction or if a record was sealed or expunged. The state evaluates this information against its moral character standards, which focus on whether past actions indicate a potential risk to the public. Failing to disclose accurate information is often more damaging than the record itself, as it raises questions regarding your honesty and integrity. Ensuring your application is complete and transparent is the most effective way to prevent unnecessary delays in your approval to sit for the exam. We will develop a systematic study roadmap that treats the licensure requirements as modular components of a professional framework. We will focus on bridging the gap between raw data points, such as those found in the statutes, and their practical application in real-world exam scenarios. By breaking down the complex relationships between the DBPR and the FREC, you will gain the clarity required to answer administrative and legal questions with absolute precision. This course is designed to strip away the ambiguity of legal jargon, leaving you with a clean mental model of how Florida real estate operations function. Success on the exam is not just about memorization, but about understanding the logical consistency of the laws governing our industry. See you in the next lecture. Welcome to the chapter on Florida real estate license law, where we will build the legal foundation necessary for your professional practice. We will dive deep into the statutes and regulations that dictate your status as a licensee within the state. To understand the regulatory landscape in Florida, we must first look at the hierarchy of authority, starting with Chapter 475, Part 1 of the Florida Statutes. This specific part of the law serves as the primary governing body for real estate sales associates and brokers, establishing the rules that keep the industry operating in a predictable manner. Complementing this is Chapter 455, which grants the Department of Business and Professional Regulation, or DBPR, the legal authority to oversee licensure processes and professional standards. We also operate under the detailed guidance of Chapter 61J2 of the Florida Administrative Code, which translates statutory intent into functional, actionable rules for everyday business. If you struggle to distinguish between the legislative intent of the statutes and the administrative implementation of the codes, you will find yourself misinterpreting your professional obligations. Understanding the distinction here is not merely academic, because professional missteps are rarely forgiven by oversight boards. You need to view these documents not as abstract theory, but as the strict boundaries within which you must conduct your business to retain your license. Mastering this legal framework is a significant investment in your career longevity and arguably the most high-leverage component of your preparation for the state exam. The concept of license status is a frequent area of confusion for those new to the field, so we must be precise about the distinctions between active, inactive, and null and void. When a licensee is actively participating in real estate services, they must be registered under an actively licensed broker or developer, maintaining an active status through proper renewal. An individual can choose to go into voluntary inactive status, which allows them to retain their license without the requirement of being employed by a broker, provided they continue their education. In contrast, involuntary inactive status happens when a licensee fails to renew their license or fails to complete the required continuing education by the deadline. If a license remains in an involuntary inactive status for more than 2 years, the license automatically becomes null and void, meaning the individual must restart the entire pre-licensing process if they wish to practice again. You should view these status categories as operational states that dictate your legal ability to perform acts of real estate. Maintaining awareness of your current status is a mandatory professional responsibility, as practicing while inactive constitutes an unlicensed activity that carries severe legal consequences. Never assume your status is active without verification through the DBPR portal, as administrative errors on the state's end have happened, and your vigilance is the only line of defense. Renewal cycles and continuing education requirements are designed to keep the profession competent and aligned with changing legislative requirements. In Florida, real estate licenses operate on a biennial renewal cycle, meaning you must complete the renewal process every 2 years. Failure to meet the continuing education threshold is the primary reason licensees are moved into involuntary inactive status, which, as we established, creates an unnecessary risk of a null and void status. The state provides clear provisions for active duty military members and their spouses, which may include licensure fee waivers or extensions on renewal deadlines to account for periods of service. Furthermore, Florida recognizes the administrative complexities of moving across state lines, utilizing mutual recognition agreements with specific jurisdictions. This is not the same as full reciprocity, as licensees through mutual recognition must still pass a Florida-specific law exam to ensure they understand the local regulatory environment. These provisions acknowledge that the real estate landscape is dynamic, and the regulatory bodies have created these pathways to ensure that qualified individuals can continue to operate despite logistical challenges. You should internalize these administrative timelines as part of your core business planning, because these events are fixed and unforgiving of forgetfulness or poor record management. The definition of whom must hold a license is broad, yet there are specific, well-defined exemptions that you must be able to identify during the exam. Generally, any person who performs real estate services for another for compensation must be licensed, but the law provides clear carve-outs for specific roles. Attorneys at law, for instance, are exempt from licensing requirements when acting within the scope of their professional legal duties to represent clients in real estate transactions. This exemption does not extend to the functions of a broker, such as charging a commission for finding a buyer, unless the attorney is also licensed under the Real Estate Commission. Court-appointed individuals, such as executors or trustees performing their fiduciary duties under a court order, are also typically exempt from the licensure requirement. Salaried property managers working for a property owner or a management company receive specific exemptions if their work involves routine maintenance, rent collection, and administrative tasks under specific statutory parameters. Recognizing these exemptions is critical because it demarcates the boundary between legal practice and unlicensed brokerage, the latter of which involves severe criminal and civil penalties. Always remember that these exemptions are narrow and should not be interpreted broadly. If you or someone else is acting as an intermediary for compensation, the burden of proof rests on demonstrating why no license is needed. The regulatory framework is comprehensive, and these laws serve to ensure a standard of ethics and competence across the entire state. I look forward to discussing how these requirements manifest in the actual organization of the Commission in the next lecture. Welcome back. We're going to explore the structure and regulatory reach of the Florida Real Estate Commission. Throughout this chapter, you will master the specific powers and organizational framework governing professional conduct in Florida. The Florida Real Estate Commission, often abbreviated as FREC, serves as the primary regulatory body for the real estate profession in the state. It is composed of 7 members who are appointed by the governor and confirmed by the Florida Senate. Among these 7 members, 4 must be licensed brokers who have held an active license for at least 5 years preceding their appointment. 1 additional member may be either a licensed broker or a licensed sales associate who has held an active license for the 2 years preceding their appointment. The remaining 2 members are required to be laypeople, meaning they have never held a real estate license or been involved in the real estate business. This specific composition ensures that a variety of perspectives, ranging from industry practitioners to the general public, are represented in regulatory decision-making. Members typically serve 4-year terms, providing continuity in the oversight of industry standards and professional ethics. By balancing industry expertise with public interest, the Commission creates a stable environment for real estate commerce. To understand how the Commission functions, we must categorize its authority into 3 distinct types: executive, quasi-legislative, and quasi-judicial. Executive powers allow the Commission to regulate and enforce the practices of the profession, including the oversight of the Division of Real Estate. The Division of Real Estate, or DRE, acts as the administrative arm that supports FREC by providing the personnel, staff, and facilities necessary to carry out its daily operations. When we talk about quasi-legislative powers, we are referring to the Commission's ability to enact rules and regulations that clarify the statutes passed by the legislature. These rules are not laws themselves, but they hold the force of law when they dictate how a licensee must operate to remain compliant. For example, the Commission establishes guidelines for office procedures, advertising standards, and the handling of escrow accounts. Because these rules are crafted by experts who understand the nuances of the market, they provide the necessary detail where statutory language might remain broad or ambiguous. The third category, quasi-judicial powers, is perhaps the most significant in terms of your day-to-day risk management as a real estate professional. This authority gives the Commission the power to grant or deny license applications, and more importantly, to discipline those who violate the administrative code. If a licensee engages in professional misconduct or fails to adhere to the statutes, the Commission acts as an administrative court to determine the appropriate penalty. These proceedings allow the Commission to issue final orders that can range from formal reprimands and the imposition of administrative fines to the suspension or even total revocation of a real estate license. When the Commission conducts these hearings, they follow a structured process that ensures due process is maintained for the individual involved. Understanding this punitive potential is critical, as it highlights that the Commission is a proactive watchdog meant to protect the public from unethical behavior. By exercising these powers, FREC ensures that the high standards expected of Florida licensees are consistently upheld across the state. See you in the next lecture. Welcome to our exploration of the foundational requirements for obtaining a Florida real estate license. In this section, we will clarify the exact criteria for licensure, the procedural path you must follow to join the profession. To begin your journey toward licensure, you must meet several non-negotiable eligibility criteria established by the Florida Real Estate Commission. Every applicant is required to be at least 18 years of age and possess a valid United States Social Security number. Furthermore, the state mandates that you hold a high school diploma or its equivalent, such as a GED certificate. Beyond these objective benchmarks, the Commission evaluates what is referred to as good moral character. This is not an abstract concept, but a practical requirement to honestly disclose any prior misdemeanor or felony convictions, including pleas of nolo contendere. Hiding such information during your application is often viewed more severely than the conviction itself and can lead to immediate denial. Being transparent about your history allows the licensing body to vet your application appropriately against statutory guidelines. Failure to meet these core requirements will halt the process before it truly begins, so ensure your documentation is accurate from the start. Taking the time to verify these eligibility markers is a crucial first step in your career. Once you satisfy the initial eligibility requirements, the next hurdle is the 63-hour pre-licensing education, often called Course I. This program is designed to provide a comprehensive foundation in real estate principles, law, and practice, which is vital for your survival in the industry. The course must be completed through a state-approved provider, and it culminates in a mandatory end-of-course exam that you must pass with a score of at least 70%. This exam serves as a gatekeeper to ensure that you have absorbed the necessary technical knowledge before moving on to the state licensing examination. If you fail this course exam, the administrative rules dictate that you must wait a specific period before attempting a different version of the test. Once you successfully clear this hurdle, you will receive a certificate of completion that is required to move forward with your official application to the Department of Business and Professional Regulation. This training is your academic foundation that prepares you for the realities of the Florida market. Submitting your application is a straightforward yet critical administrative task handled through the Department of Business and Professional Regulation online portal. You must provide all requested personal information, pay the non-refundable application fee, and submit your fingerprints for a background check. Once the department processes your application and confirms that you have met all requirements, they will issue you an authorization attest. This digital authorization is the key that unlocks your ability to schedule the state licensing examination. You cannot simply show up at a testing center. You must possess this specific approval to sit for the exam. Ensure that your contact information remains up to date in the portal throughout this process to receive timely notifications from a state. Keeping your digital record accurate prevents delays and ensures that you receive your authorization as quickly as the bureaucratic workflow allows. Even after passing the state exam and receiving your initial sales associate license, your education is far from complete. New licensees are subject to a post-licensing requirement that mandates an additional 45 hours of education, which must be completed within the first renewal period of your initial license. This post-licensing education is intended to transition you from the theoretical world of the pre-licensing course to the practical application of real estate business. Failure to complete this requirement by the deadline results in the expiration of your license, effectively rendering you unable to practice until you satisfy the deficiency. Once this post-license period is resolved, you transition to standard continuing education cycles for subsequent renewals. This process ensures that you maintain a baseline level of professional competence as you integrate into the industry. For those who advance to the brokerage level, the rules regarding business structure become more complex through the use of group and multiple licenses. A group license is a specific mechanism that allows a sales associate or broker associate to work for one owner-developer who owns multiple properties through different legally registered entities. By holding a group license, the associate can perform tasks for all those associated entities under the same umbrella. In contrast, multiple licenses are strictly reserved for brokers who need to hold more than one broker license to manage different brokerage firms concurrently. This secondary structure is designed to accommodate complexity in business ownership while ensuring the Florida Real Estate Commission retains oversight of every active entity. Understanding these distinctions is fundamental to staying compliant while expanding your operational capacity as a licensed professional in the state. Catch you in our next session. Welcome back to our journey through the legal framework of Florida real estate, where we will now shift our focus to the operational foundations of a brokerage business. In this chapter, we will examine the specific physical and regulatory burdens placed upon brokers to ensure transparency and consumer protection in the marketplace. Establishing a physical office in Florida is not merely a formality, but a foundational legal requirement that every active broker must satisfy. According to the regulations set forth by the Florida Real Estate Commission, each active broker must maintain an office which must be registered with the Department of Business and Professional Regulation. This office must be located in an enclosed building of stationary construction that provides the necessary privacy to conduct negotiations and closings between parties. The requirement for an enclosed room is strictly enforced because the nature of real estate transactions involves the sensitive handling of legal documents and private financial information. If a brokerage operates out of a space that lacks this private, enclosed area, it fails the statutory requirement for an office location. It is worth noting that while the office must exist, there is no mandate that it be located within the state of Florida itself, provided the broker maintains the necessary registrations and operational standards. However, the requirement for privacy remains constant regardless of the geographic location of the physical office space. Signage at the principal office is another critical area where the Florida Real Estate Commission mandates absolute clarity for the public. Every broker must display a sign on or near the entrance of the office that is easily observable by anyone entering the premises. This sign must explicitly state the trade name of the brokerage, the name of the broker, and the designation licensed real estate broker. By requiring these specific elements, the Commission ensures that any consumer who walks into the office knows exactly who is responsible for the business and understands the licensing status of the entity. Failure to display a sign meeting these requirements can lead to disciplinary action against the broker as it misleads or obscures the identity of the firm from potential clients. This regulation serves as a safeguard, preventing unlicensed individuals from holding themselves out as brokers through deceptive practices. Maintaining a professional and compliant entrance is therefore an essential component of professional conduct. When it comes to the expansion of a business, the rules regarding branch offices are similarly rigid. If a broker decides to conduct business at a location other than their principal office that is of such nature that the public would reasonably believe it to be a branch of the brokerage, that location must be registered as a branch office. Unlike the registration for a principal office, a branch office registration is non-transferable under any circumstances. This means that if a firm chooses to move a branch location or close it down, the registration cannot be moved to a new site at the whim of the broker. Each physical branch location must independently meet the registration requirements and receive its own distinct branch office registration from the Department of Business and Professional Regulation. By treating each location as a distinct entity, the Commission maintains granular oversight of where real estate activities are occurring across the state. Advertising rules are designed to prevent the appearance of unlicensed activity and ensure that all professional representations are accurate and honest. A primary prohibition in this arena is the use of blind advertisements, which are defined as ads that fail to disclose the identity of the brokerage firm. To be compliant, every piece of real estate advertising, whether in print, on the radio, or in digital media, must clearly identify the name of the brokerage. If a sales associate chooses to include their own name in an advertisement, the brokerage name must be listed in a manner that is at least as prominent as the individual's name. This ensures that the public is never confused about which firm holds the responsibility for the transaction or the specific professional relationship involved. When dealing with advertising, you should always err on the side of making the brokerage identity the most visible part of the outreach. Digital and social media advertising follow the same strict accountability standards as traditional media, regardless of the limitations of the platform. In the context of the internet, the brokerage name must be clearly identifiable on the main page of any website or social media profile used to conduct real estate business. If a user clicks on a link or searches for a professional, they should not have to hunt for the brokerage name or be led to believe the individual is operating independently. Modern real estate business involves significant digital presence, but this shift in medium does not grant brokers or their sales associates an exemption from identifying the brokerage entity. Because the internet can be a space for anonymous communication, these rules serve as a vital constraint that forces professionals to stand behind their brand identities online. Failing to include clear brokerage information on a digital platform is treated with the same severity as failing to place a sign on a physical door. Proper institutional identification protects both the broker and the consumer during the advertising and transaction process. See you in the next lecture. Welcome. Let's begin our deep dive into the regulatory boundaries and exemptions regarding who can provide real estate services in Florida. Mastering these distinctions is essential for protecting your license and understanding the limits of your professional practice. To understand the core of Florida real estate law, we must first address the specific activities that mandate holding a valid real estate license. The mnemonic at bar sale acts as a reliable framework for remembering these services, which cover appraising, buying, auctioning, renting, selling, exchanging, and leasing. It is critical to note that while an appraiser must generally follow a SPAP guidelines, an individual performing a comparative market analysis or an estimate of value for brokerage purposes does not necessarily act under those stringent appraisal standards, provided they are not representing themselves as a licensed appraiser. Whether you are facilitating an auction for a client or assisting in the exchange of commercial properties, the intent of the compensation or the promise of compensation triggers the requirement for licensure. If you're conducting these tasks for another person and you expect a fee or commission, you are engaging in regulated activity. This framework is not merely a box-checking exercise for regulators, but a direct consumer protection mechanism designed to ensure that those facilitating high-stakes transactions are held to a state-mandated standard of conduct. By grouping these specific actions into the bar sale model, the Florida Real Estate Commission defines the exact scope of oversight. Failure to recognize that even a seemingly minor act, like listing a neighbor's property for a small referral fee, falls under these definitions, is a common path to regulatory scrutiny. While the law is broad in its reach, there are specific, well-defined exemptions for individuals who do not require a license to conduct real estate activities. The most straightforward exemption applies to property owners, including individuals, corporations, or partnerships who buy, lease, or sell their own property. Because these entities are protecting their own equity and capital, the state does not require them to demonstrate the same level of professional testing as those acting for others. Furthermore, salaried employees of an owner-developer are exempt, provided they are not paid on a transactional basis or commission. This distinction is vital because it shifts the focus from the act itself to the compensation model being used. If a salaried employee starts receiving a per-closing bonus, they have effectively crossed the line into brokerage activity that requires licensure. We also see exemptions for court-appointed individuals, such as trustees or personal representatives, who are fulfilling specific legal duties mandated by a judge. These individuals are acting as extensions of the court system rather than as private commercial facilitators, which renders licensure unnecessary for their specific tasks. Understanding these boundaries allows you to evaluate potential client arrangements and verify if the parties you're interacting with are operating legally within the established statutory framework. The regulatory environment becomes particularly nuanced when addressing the roles of unlicensed personal assistants or on-site rental staff. A common misconception in the field involves the delegation of tasks by licensed brokers to unlicensed support staff. While these individuals can perform clerical duties, such as scheduling appointments, inputting listing data, or handling office correspondence, they're strictly prohibited from engaging in activities that require professional judgment or negotiation. An unlicensed assistant cannot show properties, host open houses, or attempt to negotiate the terms of contract or commission with a client. If an unlicensed assistant picks up the phone to perform cold calling or engages in active solicitation of business, they are essentially practicing brokerage without a license. This restriction protects the public by ensuring that those who guide or advise clients have undergone the required education and background vetting. If you find yourself in a supervisory role, it is your responsibility to monitor your assistants closely to ensure they stay within these administrative boundaries. Violating these prohibitions does not just threaten the assistant. It places the broker's own license in direct jeopardy due to a failure to supervise effectively. We must conclude our discussion on this topic by examining the intersection of compensation, kickbacks, and referral fees. Under Florida law and the federal requirements of the Real Estate Settlement Procedures Act, or RESPA, the flow of money between service providers is heavily restricted to prevent conflicts of interest. The fundamental rule is that a real estate licensee cannot accept a kickback or an unearned fee from anyone providing settlement services in a transaction. When you refer a client to a title company, a home inspector, or a mortgage lender, receiving a direct payment for that referral is generally considered an illegal act. While business relationships are encouraged, they must be founded on transparency and the actual provision of services. Any bonus or fee that is not documented and clearly disclosed to all involved parties during the closing process undermines the integrity of the transaction. Hotel operators and short-term rental managers similarly occupy a specific niche where they may facilitate rentals, but they must strictly adhere to the limits of their authority to avoid acting as unlicensed brokers. Maintaining clear records of how and why payments are made is your best defense against accusations of professional misconduct. By internalizing these constraints on referrals and compensation, you ensure that your practice remains ethical and compliant with the stringent expectations of the Florida Real Estate Commission. See you in the next lecture. Welcome back. This chapter focuses on the Florida Real Estate Commission's disciplinary process and the critical legal consequences for professional misconduct. The disciplinary process governed by Florida Statute 455 is a structured 7-step sequence designed to protect the public while ensuring due process for licensees. It begins with the filing of a complaint, which the Department of Business and Professional Regulation investigates to determine if a violation has occurred. Once the investigation report is compiled, it is submitted to a probable cause panel, which consists of 2 FREC members who determine if there is enough evidence to proceed. If they find probable cause, a formal complaint is issued against the licensee, detailing the specific charges. The licensee then has the right to respond through either an informal hearing before the commission or a formal hearing presided over by an administrative law judge. When a formal hearing is required, the administrative law judge acts as an independent arbiter who submits a recommended order back to the commission. The FREC then issues a final order, which may impose sanctions or dismiss the charges entirely based on the findings. Finally, the licensee maintains the right to seek a judicial review of the final order in the appropriate district court of appeal. Understanding the distinction between informal and formal hearings is vital because the choice significantly alters the trajectory of your licensure status. An informal hearing before the FREC is common when a licensee does not dispute the facts of the case, but merely wishes to present mitigating circumstances before a penalty is assigned. In contrast, a formal hearing involves an administrative law judge from the Division of Administrative Hearings, occurring specifically when a licensee disputes the material facts of the case. The administrative law judge possesses the authority to issue subpoenas, take testimony, and create a record for the final decision. This adversarial process ensures that professionals have a venue to challenge evidence before their livelihood is affected by the FREC. Once the judge submits their recommended order, the FREC retains the ultimate authority to accept, reject, or modify those findings in their own final order. It is a rigorous system that demands a precise understanding of which hearing types apply to specific legal disputes. When a violation is established, the Commission exercises its authority to impose tiered penalties depending on the severity of the offense. These sanctions often include administrative fines, which can reach up to $5,000 per violation, as well as the suspension or permanent revocation of a real estate license. For minor offenses, the department may issue a citation, which is essentially a streamlined fine meant to address administrative errors without the need for a full hearing. However, serious or ongoing behavior often leads to mandatory suspension periods or total expulsion from the industry. Furthermore, unlicensed activity in Florida is treated as a severe matter that frequently crosses into the jurisdiction of the criminal court system. These activities can result in third-degree felony charges, carrying their own set of independent criminal fines and potential incarceration periods. It is the responsibility of every licensee to maintain compliance, as ignorance of these disciplinary paths is never considered a valid legal defense. The Real Estate Recovery Fund serves as a final safety net for members of the public who suffer monetary losses due to the fraudulent or dishonest actions of a licensee. A claimant must obtain a valid civil judgment against the broker or sales associate and exhaust all efforts to collect the funds from the licensee's personal assets before requesting assistance from the fund. There are strict statutory limits on these disbursements, specifically capping a single judgment at $50,000. For multiple claims arising from the actions of a single licensee, the fund is capped at a total aggregate limit of $150,000. Once a payment is made from the fund on behalf of a licensee, their license is automatically suspended until they have repaid the full amount with interest. This mechanism ensures that the integrity of the profession is upheld, as the industry effectively takes responsibility for the damages caused by its offending members. Self-disclosure is perhaps the most overlooked responsibility in the entire regulatory framework, yet remains mandatory for every active licensee in Florida. According to the board rules, any licensee who is convicted of a crime, regardless of where or when it occurred, must report the conviction to the department within 30 days. Failure to provide this notification is a separate disciplinary offense that can lead to additional sanctions, potentially worse than the initial underlying conviction itself. This reporting requirement applies to misdemeanors and felonies, including those unrelated to real estate, such as drug possession or traffic-related offenses. The purpose of this rule is to maintain transparency and ensure that the department can evaluate whether the individual remains fit to interact with the public. You must document this disclosure properly, as the burden of proof for satisfying this ethical requirement resides entirely with the licensee. I look forward to seeing you in our next session. Welcome back. In this chapter, we will examine the Brokerage Relationship Disclosure Act to clarify how you must legally represent parties in Florida real estate transactions. Understanding these relationships is the most critical hurdle you will face on the exam, as it dictates the fiduciary or transactional obligations you owe to buyers and sellers. You will learn the specific definitions of residential versus non-residential property, which determines the scope of your disclosure requirements. We will also demystify the 3 primary brokerage relationships allowed under Florida statutes and why transaction brokerage is the default. Mastering this material is not just about passing a test. It is about protecting your license by ensuring your professional conduct aligns strictly with FREC regulations. This course provides the structural framework you need to navigate these complex legal nuances with total professional confidence. The foundation of Florida brokerage law rests on the Brokerage Relationship Disclosure Act, which explicitly mandates how a licensee communicates their role to the public. Under Florida law, it is essential to distinguish between residential and non-residential sales, as the definition of residential property dictates the rigor of your disclosure requirements. Specifically, residential sales are defined as the sale of improved residential property of 4 units or fewer, or the sale of unimproved residential property intended for use as 4 units or fewer. Additionally, agricultural property of 10 acres or fewer is classified as residential for the purposes of these disclosure laws. If a transaction falls outside these specific parameters, it is considered non-residential, and different disclosure protocols apply. Misidentifying the property category can lead to severe disciplinary actions, so you must internalize these thresholds early in your study. One of the most consequential aspects of Florida license law is the categorical prohibition of dual agency. In many other jurisdictions, a licensee might attempt to represent both the buyer and the seller as a fiduciary, but Florida law strictly prohibits this practice. This is because representing 2 opposing parties in a fiduciary capacity creates an inherent conflict of interest that is incompatible with the duty of loyalty. Consequently, if you were to attempt to act as a dual agent, you would likely be subject to immediate disciplinary investigation by the Commission. Instead, Florida law provides the transaction brokerage relationship as the standard, which avoids the pitfalls of dual agency while still allowing the licensee to facilitate the transaction. Understanding this distinction is vital, as the exam will frequently test your ability to identify and reject scenarios involving dual agency. Florida law recognizes 3 distinct brokerage relationships: non-representation, transaction brokerage, and single agency. Unless the parties have entered into a different written agreement, Florida law creates a statutory presumption that a licensee is operating as a transaction broker. This means that if you perform brokerage services without a signed disclosure or a defined agency agreement, the law assumes you're acting as a facilitator rather than a fiduciary. A transaction broker provides limited representation to a buyer, a seller, or both, without representing either party in a fiduciary capacity. In this relationship, your duty is to facilitate the transaction honestly and fairly, but you are not obligated to follow instructions that would violate the law. This relationship is fundamentally different from a single agency, where you act as a fiduciary for only one party. The primary contrast between these relationships lies in the duties owed to customers versus clients. When you act as a single agent, you enter into a fiduciary relationship with your principal, which carries heightened legal obligations, including full confidentiality, loyalty, and obedience. In contrast, a transaction broker serves customers, not clients, and does not owe the fiduciary duties of loyalty or full disclosure of all information. Instead, a transaction broker must provide limited confidentiality, which is a nuanced requirement that prevents you from disclosing a party's motivation or price point without written permission. Because of these distinct legal burdens, the law requires specific written disclosures for residential transactions when you are acting as a single agent or when you are operating with no brokerage relationship. These documents serve as your primary defense, ensuring that all parties are properly informed of their rights and your level of responsibility. See you in the next lecture. Welcome back. In this lesson, we will parse the specific requirements and operational limits of the transaction broker relationship under Florida law. When you operate as a transaction broker, You act as a neutral facilitator rather than a fiduciary agent for either party. This relationship, which is the default in Florida real estate unless otherwise specified, implies that you provide limited representation to both the buyer and the seller as customers. Because you're not representing either party in a fiduciary capacity, you avoid the conflict inherent in dual agency, which is prohibited in this state. Your role shifts from being an advocate for one side to becoming a coordinator of the transaction process. You must understand that this neutrality is not an absence of responsibility, but a carefully defined set of boundaries that protects both the licensee and the participants. Mastery of these duties is essential because the Florida Real Estate Commission mandates strict adherence to these standards to ensure fair play in every deal. By maintaining this neutral stance, you help move the transaction toward a closing while managing the expectations of both the buyer and the seller. The foundation of the transaction broker relationship rests upon 7 mandatory duties that you cannot waive under any circumstances. First, you must deal honestly and fairly, which serves as the bedrock of every real estate interaction regardless of your agency designation. Second, you are required to account for all funds entrusted to you, ensuring that deposits and earnest money are handled in strict compliance with state regulations. Third, you must use skill, care, and diligence, providing professional competence that a reasonable person would expect from a licensed real estate practitioner. Fourth, you must disclose all known material facts that affect the value of the residential property, even if those facts are not immediately obvious to the parties. Fifth, you are obligated to present all offers and counteroffers in a timely manner, allowing the principals to make their own informed decisions. Sixth, you must maintain limited confidentiality, which is a nuanced obligation that we will examine closely. Finally, you may perform any additional duties that the parties have agreed upon in writing, provided those tasks do not conflict with your core neutral obligations. The concept of limited confidentiality is perhaps the most critical distinction in the transaction broker relationship compared to others. In a traditional fiduciary relationship, you might be required to advocate for a client's specific financial position, but as a transaction broker, you cannot disclose certain sensitive motivations. Specifically, you are prohibited from revealing to the seller that the buyer is willing to pay a price higher than the one offered in the written contract. Conversely, you cannot tell the buyer that the seller is willing to accept a price lower than the current asking price. You also cannot disclose any other information that either party requests to remain confidential, unless that disclosure is required by law or necessary to prevent a fraudulent transaction. This restriction exists to ensure that neither party gains an unfair tactical advantage through your knowledge of their private limitations. By keeping these financial ceilings and floors to yourself, you facilitate a negotiation based on market reality rather than psychological leverage. Your role as a neutral facilitator requires a high degree of emotional intelligence and professional discipline. You are essentially the architect of the deal, ensuring that the necessary paperwork, disclosures, and communications flow smoothly between the buyer and the seller. You do not advocate for the highest price for the seller or the lowest price for the buyer. Instead, you provide the information necessary for them to arrive at a value they both accept. If you find yourself in a situation where you feel a strong desire to protect one party's bargaining position, you must pause and remind yourself of your duty to remain neutral. Failure to maintain these boundaries can lead to accusations of biased representation, which can jeopardize your license and the transaction itself. Always remember that the transaction broker relationship is designed to simplify the process while maintaining a baseline of ethical conduct that protects the integrity of the market. You are there to bridge the gap between two parties, not to participate in their strategy or influence their bottom line beyond the presentation of facts. See you in the next lecture. Welcome to our deep dive into the single agent relationship, a critical cornerstone of Florida real estate law. We will examine the rigorous fiduciary standards and the specific mandates that define how a broker operates as a representative for a principal. In a single-agent relationship, the real estate broker acts as an agent for either the buyer or the seller, but never both in the same transaction. This creates a relationship defined by a high fiduciary standard, which is the legal equivalent of a position of trust and confidence. When you serve as a single agent, you're essentially the legal representative of your principal, meaning you must be entirely committed to their interests above all others in the transaction. This differs significantly from a transaction broker relationship, where the broker acts as a facilitator rather than an advocate. The principal, in this context, is the party, either buyer or seller, who has entered into the agency agreement with the broker. Because this relationship is so powerful, the law imposes strict requirements on how it must be established and how it must be maintained. To ensure clarity and compliance, a single agent relationship must be established in writing. This transition or initiation must occur before or at the time of entering into a listing agreement or a buyer representation agreement. This written notice serves as proof that the principal understands you are now acting as their fiduciary agent, bound by strict duties that go beyond basic professional courtesy. You cannot simply imply a single agent relationship through conduct. The statute requires clear, documented evidence. Once this relationship is formalized, you are legally constrained to prioritize the principal's best interests in every material decision. If you fail to maintain these standards, you risk not only losing your commission, but also facing disciplinary action from the Florida Real Estate Commission. The heart of the single agent relationship lies in the 9 mandatory duties required by Florida law. You are expected to demonstrate honesty and to account for all funds entrusted to you, which are fundamental to any professional relationship. You must also exercise reasonable skill and care, ensuring that you perform your tasks with the diligence of a prudent expert. Perhaps most importantly, you have an affirmative duty to disclose all known material facts that affect the value of the property. These 4 duties, honesty, accounting, skill, and disclosure, are considered the core foundation of your professional conduct in any brokerage arrangement. However, the single agent relationship adds an extra layer of responsibility that sets the fiduciary bar significantly higher. The most distinct features of the single agent relationship are captured by the acronym COLD, which stands for confidentiality, obedience, loyalty, and disclosure. Confidentiality means you may never divulge any information that could compromise your principal's bargaining position, such as their maximum offer price or their motivation for selling. Obedience requires that you follow all legal instructions provided by your principal, even if those instructions are inconvenient, provided they remain within the bounds of the law. Loyalty is the requirement that you place the principal's interests ahead of all others, including your own financial interests. Finally, full disclosure requires that you inform the principal of all pertinent information concerning the transaction that could influence their decision-making process. These duties are absolute and represent the highest level of professional obligation in the industry. Understanding these duties is the key to navigating the complexities of Florida real estate law, as failing to adhere to them can have severe legal consequences. For instance, if you obtain confidential information about a seller's desire to offload a property quickly, you are forbidden from revealing that to a potential buyer. Doing so would be a breach of your fiduciary duty of confidentiality, as it harms the principal's ability to negotiate the best possible price. Similarly, if your principal instructs you to seek a specific counteroffer strategy, you must abide by that request so long as it is legal. The burden is heavy, but it is precisely this high level of service that justifies the single agent designation. By mastering these 9 duties, you position yourself as a professional who truly understands the legal weight of representation. See you in our next session. Hello. Let us look at the specific requirements when you interact with a person without establishing an agency relationship. In the Florida real estate landscape, You will frequently encounter scenarios where a customer is not your client, meaning you occupy a position of no brokerage relationship. Understanding this distinction is fundamental because it defines the exact scope of your legal obligations when you do not hold a fiduciary or contractual duty toward that individual. When you act in this capacity, you are not an agent, yet you remain a licensee subject to the rules of the Florida Real Estate Commission. The law mandates that you perform your duties with professional integrity, even without the heightened loyalty required in a single agency or transaction broker relationship. By maintaining these boundaries, you protect both the licensee and the customer from accusations of undisclosed representation. You must remember that this role is the default setting for any licensee interacting with a member of the public unless a formal agreement has been established to the contrary. Providing clarity here prevents misunderstandings that could lead to disciplinary actions or legal disputes over unintended representation. The primary duty you owe in a non-representation scenario is to deal honestly and fairly at all times. This is an objective standard that requires you to avoid fraud, misrepresentation, or any form of deception in your interactions with a customer. Being honest means you do not provide false information regarding the condition of the property or the nature of any financial obligations. Being fair involves conducting your professional affairs in a transparent manner that does not deliberately disadvantage the other party through withholding critical information by design. You should view this not as a burden, but as the baseline requirement for maintaining your license in the state of Florida. Even if you do not represent the buyer or the seller, you remain responsible for the accuracy of the information you convey. This duty exists regardless of whether the other party has their own representation or is proceeding entirely on their own. Beyond general honesty, you face a specific demand regarding the disclosure of known facts that materially affect the value of residential real property. You are responsible for revealing any issues that are not readily observable to a potential buyer, provided those facts are within your actual knowledge. If you know of a structural defect, a significant mechanical issue, or a legal encumbrance that would reasonably cause a buyer to change their decision to purchase, you cannot remain silent. The threshold is whether the condition would typically affect the value of the property and whether a reasonable person walking through the premises would be able to spot the flaw immediately. If the defect is hidden, such as a dormant issue behind a wall or a title complication, your duty is to disclose it, even if you're not the agent for the buyer. Failing to speak up in these instances is a violation of your legal obligations and can be interpreted as a failure to disclose material information. The third primary duty is the strict accounting for all funds entrusted to you. If a customer provides you with an earnest money deposit or any other funds related to a real estate transaction, you are essentially a fiduciary over those specific monies, regardless of your broader relationship with the customer. You must deposit these funds into an appropriate escrow account within the required time frame mandated by state statute. You cannot treat these funds as your own, and you must maintain complete, accurate, and accessible records of how every penny is handled from receipt to disbursement. This duty of accounting persists even when you have no formal brokerage agreement, as the protection of public funds is a pillar of the Florida license law framework. If those funds are mishandled, the lack of an agency relationship provides you with no defense against regulatory sanctions. You must provide the written no brokerage relationship notice to the customer before showing them any property. This notice serves as a formal declaration that you are not representing them in the transaction, which is essential when you are acting as an agent for the other party. Consider a scenario involving a for sale by owner transaction where you represent a buyer. Because the seller is unrepresented, you have a duty to inform them of your role immediately so they do not mistakenly believe you are protecting their interests. By serving this notice early, you establish clear expectations and demonstrate that you are performing your required duties while maintaining a professional distance. It is not sufficient to simply mention this verbally. It must be a clear notification, often provided via a standard form, to document that the customer understands their lack of representation. The appropriateness of this relationship often arises in commercial dealings or when a licensee manages an open house for a seller they do not represent. In these cases, you are acting as a facilitator who provides information without the baggage of agency. This model allows the public to interact with licensees without feeling pressured into a contract, while ensuring that the licensee still adheres to basic ethical standards. It is a clean, well-defined relationship that minimizes the complexity of the interaction. Once you understand the duties of fairness, disclosure, and accounting, you will see that this is a manageable administrative task rather than an ambiguous gray area. By strictly following the notification process and maintaining your professional standards, you insulate yourself from the most common pitfalls encountered in daily practice. I will see you in the next lecture. Welcome back. In this lesson, we will examine the precise legal mechanics required to transition from a single agent relationship to a transaction broker relationship under Florida law. In the landscape of Florida real estate, a broker acting as a single agent owes fiduciary duties to their principal, including loyalty, obedience, and full disclosure. These fiduciary duties are inherently incompatible with a dual agency scenario, which Florida law expressly prohibits to keep the professional relationship transparent and fair. When a single agent encounters a situation where they represent a buyer who is interested in a property listed by that same agent's brokerage, a conflict of interest emerges. To resolve this without abandoning the client, the broker must transition the relationship to a transaction broker status. This change in capacity is not a subtle shift in tone, but a fundamental change in the legal duties owed to the parties involved. If this transition is not handled with explicit procedural rigor, the broker risks violating FREC regulations, which can result in severe disciplinary action against their license. The primary mechanism for this transition is the consent to transition to transaction broker notice, a mandatory legal document that must be signed by the principal. Without this written consent, the broker cannot legally operate under the limited representation of a transaction broker while maintaining their prior single agency obligations. The purpose of this notice is to ensure that the principal fully understands that they are moving from a position of absolute loyalty and confidentiality to one of limited representation. You can think of it as a reset button on the scope of the broker's authority, moving from representing one party's interests above all others to facilitating a transaction between parties. The principal might consent to this transition because, without it, the broker would be unable to show the property in question to a buyer who is also represented by the same firm. By consenting, the seller gains access to a broader pool of potential buyers while the broker remains within the bounds of legal compliance. When analyzing the duty of confidentiality, we see the most significant shift during this transition process. As a single agent, the broker is strictly prohibited from revealing any information that might weaken the client's bargaining position, such as their willingness to accept a lower price or their financial motivations. After transitioning to a transaction broker, the duty of confidentiality is restricted to ensuring that the party's motivation for the transaction or their negotiation strategies remain protected provided they have not already been disclosed. The duty of loyalty, which is a hallmark of the single agent relationship, is effectively replaced by a duty of limited representation. In the transaction broker relationship, the broker does not advocate for either party and instead focuses on assisting both sides to reach a mutually acceptable agreement. It is your job as a licensee to understand that this does not mean the broker is suddenly neutral in a vacuum, but rather that the broker's role is defined by facilitation rather than partisan advocacy. Compliance with these requirements is non-negotiable, and the timeline for these disclosures is embedded into the foundation of Florida brokerage law. You must secure the signed consent before the transition occurs, as attempting to retroactively apply this change is a common trap that leads to disciplinary proceedings. If a broker fails to obtain the signature, they're essentially acting in an unauthorized capacity, which the Florida Real Estate Commission views as a major breach of conduct. It is helpful to view the consent to transition to transaction broker notice as a protective barrier for both the client and the licensee. For the client, it defines the limits of the broker's duties so they can adjust their expectations accordingly. For the licensee, it provides a clear, documented audit trail that demonstrates an adherence to the law, protecting the license from claims of undisclosed dual agency. I look forward to our next session together. Welcome back to our exploration of agency relationships under Florida law. In this segment, we will analyze the specific requirements and operational parameters of the designated sales associate status. In the world of commercial real estate, transactions often involve sophisticated parties with substantial assets, leading to unique agency requirements under Florida statutes. The designated sales associate rule is a tailored provision designed specifically for non-residential transactions where both the buyer and the seller possess assets of at least $1 million. When these conditions are met, a broker may designate two individual sales associates to act as single agents for the buyer and seller respectively within the same transaction. This is a crucial exception to the general rule prohibiting the simultaneous representation of both sides by the same brokerage in a single agency capacity. By utilizing this framework, corporate or high net worth entities maintain the benefits of full fiduciary representation, which is otherwise restricted or neutralized in typical transaction brokerage arrangements. It is important to emphasize that this flexibility exists exclusively in the commercial sector and cannot be applied to residential transactions under any circumstances. The mechanics of this arrangement require careful attention to the broker's role and the formal documentation process. While the two designated sales associates assume the role of single agents for their respective clients, the broker remains in a neutral, supervisory capacity throughout the process. The broker does not act as a single agent for either party, but instead acts as a facilitator who ensures both sides receive a high level of fiduciary care. This arrangement necessarily impacts the standard fiduciary duties, as the associates are relieved of the inability to act as single agents when they are properly assigned under this specific statute. However, the integrity of this structure hinges entirely on full transparency and written consent from all involved parties. This is fundamentally different from a transaction brokerage relationship, where fiduciary duties are significantly reduced in favor of a neutral role that serves the transaction rather than solely the principal. To legally transition into the designated sales associate structure, the parties must execute a formal disclosure notice. This document is not merely a formality, but a mandatory legal instrument that provides essential protection to the broker and clarity to the clients. The disclosure must explicitly state that the requirements for asset thresholds have been satisfied and that both the buyer and the seller are consenting to this specific agency arrangement. By signing this notice, the parties acknowledge that they are effectively waiving the standard protections or limitations they might otherwise encounter in a standard brokerage relationship. Failure to properly prepare, present, or obtain signatures on this disclosure can result in significant regulatory scrutiny and exposure for the brokerage. The broker is tasked with maintaining these records in compliance with the Florida Real Estate Commission rules governing transaction files and documentation retention. Professionals must treat this process with the same level of administrative diligence applied to every other legal disclosure in the Florida real estate landscape. The rationale behind this rule is to provide high-asset entities with the legal ability to retain a single agent, even when the same broker handles both sides of the deal. In traditional single agency, if a broker represents one party, they cannot legally represent the opposing party in the same deal without violating their fiduciary duty. By designating specific agents, the law creates a firewalled environment where those agents can exercise loyalty, confidentiality, and full disclosure for their individual principals. This keeps the transaction moving efficiently without stripping away the professional advocacy that high-level commercial clients expect. If you encounter a situation involving large commercial assets, evaluating the viability of designating sales associates should be at the forefront of your strategic planning for the client. Keeping these specific transactional requirements in mind will prevent common errors during property acquisitions or dispositions. I will see you in the next part of our series. Welcome to this lesson on mandatory disclosures, a critical pillar of Florida real estate practice. We will explore the specific legal requirements that ensure transparency and protection for all parties in a transaction. In Florida, the doctrine of caveat emptor, or let the buyer beware, has been significantly curtailed by judicial precedent and statute. The foundational case in this area is Johnson versus Davis, which fundamentally altered the landscape of real estate sales by establishing an affirmative duty for sellers to disclose all known material defects. A material defect is essentially any fact that could adversely affect the value of a property and is not readily observable to the buyer. Before this ruling, a seller could largely remain silent unless specifically asked about a condition. But now that willful silence regarding hidden defects constitutes potential fraud. This duty is not limited to residential property, but is a standard that professional licensees must help their clients navigate. You must remember that this disclosure obligation persists even in cases where the property is being sold in as-is condition. The seller's disclosure obligation is not about fixing every fault, but about ensuring the buyer has the information necessary to make an informed decision based on the actual condition of the asset. Failing to adhere to this standard risks litigation and potential loss of your professional license if you played a role in concealing such information. Another essential disclosure involves the potential presence of lead-based paint in properties constructed prior to 1978. Federal law requires that sellers and landlords provide buyers or tenants with a specific EPA-approved disclosure form, an informational pamphlet regarding the dangers of lead exposure. Failure to provide this documentation before the ratification of a contract allows the buyer a period of time to conduct an assessment or risk inspection, or even to rescind the agreement entirely. You must ensure that this disclosure is executed correctly, as the penalties for noncompliance are severe and can include significant federal fines alongside private civil liability. Similarly, the Florida statutes mandate that buyers be provided with a radon gas notification. This notification is meant to inform the party that radon is a naturally occurring radioactive gas that may accumulate in enclosed spaces if not properly mitigated. While the law does not strictly require testing or mitigation before closing, it emphatically mandates that the nature of the gas be disclosed in writing to the buyer prior to or at the time of the execution of the contract. Energy efficiency is another area subject to legislative oversight, requiring that buyers be presented with a brochure concerning the potential for energy efficiency ratings. This disclosure is intended to encourage buyers to request an energy efficiency rating on the building, which can help estimate potential utility costs and energy consumption. Furthermore, when a property is subject to a homeowners association, the requirements under Chapter 720 of the Florida statutes become paramount. If a property is governed by an HOA, the seller is obligated to provide the buyer with a disclosure summary regarding the assessments, restrictive covenants, and the potential for mandatory membership. This disclosure must be presented before or at the time of the execution of the contract, and if it is not, the buyer retains the statutory right to void the contract within a specific window of time. Providing this late is a common error, so you must treat it as a priority at the very beginning of the transaction lifecycle to avoid rendering a contract unenforceable. Property taxes and environmental factors like flood zones and mold also require explicit transparency to prevent future disputes. The property tax disclosure informs the buyer that the current property taxes paid by the seller may change significantly once the property is reassessed after a change in ownership. Many buyers mistakenly assume that the taxes will remain exactly as they were during the seller's occupancy, which leads to surprises that can jeopardize the closing process. Simultaneously, disclosing the property's location within a special flood hazard area is necessary for the buyer to determine the necessity of flood insurance and comply with mortgage lender requirements. As for mold, although no single specific statute mandates a generic mold disclosure form, the broader principles established by case law and general disclosure obligations make it standard practice to disclose any known persistent moisture or mold issues. You are expected to facilitate the delivery of these disclosures within strict timelines, as delays can lead to legal complications. Keeping organized records of when and how these disclosures were provided to the other party is one of the most effective ways to protect your clients and your own professional standing. I look forward to discussing how these requirements integrate with transaction workflows in our next session. Welcome back. In this lesson, we will examine the regulatory framework governing escrow accounts and the specific procedures for handling trust funds under Florida law. When a buyer provides an earnest money deposit, they are essentially entrusting the broker with funds that do not yet belong to the seller. Consequently, the law imposes a strict timeline to ensure these assets are protected from loss or misappropriation. If you're a sales associate, you have a very narrow window to turn those funds over to your broker. You must deliver the deposit to your employing broker by the end of the next business day following receipt. This deadline does not allow for personal errands or delays, as the clock starts ticking the moment you accept the check or cash. Once the broker receives these funds, the legislative requirement for deposit becomes even more specific. The broker is mandated to place the funds into an escrow account no later than the end of the third business day following receipt. Saturdays, Sundays, and federal holidays are not considered business days for the purpose of counting this deadline. Failure to meet these specific timeframes is a violation of Florida Administrative Code and can lead to serious disciplinary action by the FREC. The account where these funds reside must be situated within the state of Florida to remain under the jurisdiction of state regulators. Acceptable institutions include Florida-based commercial banks, savings associations, or credit unions. Alternatively, a broker may choose to deposit the funds into a trust account maintained by a title company or a Florida attorney if that is specified in the purchase contract. It is important to remember that the broker is ultimately responsible for the funds, even if they are held by a third party. Brokers must maintain complete records of all deposits, withdrawals, and balances. This includes maintaining a clear audit trail that tracks every dollar from receipt to the final disbursement. If a broker keeps the funds in an interest-bearing account, they must have the written permission of all parties involved to do so. They must also clearly specify who is entitled to the interest earned during the holding period before the transaction closes. A significant risk in brokerage management involves the concepts of commingling and conversion. Commingling occurs when a broker mixes personal or business operating funds with the trust funds of their clients. This is strictly prohibited because it obscures the line between client assets and agency assets. The only exception where a broker may keep a small amount of personal money in an escrow account is to cover service fees charged by the bank. Even then, the amount must be minimal and explicitly recorded to avoid the appearance of impropriety. Conversion happens when a broker takes the client's money and uses it for their own purposes, essentially stealing the deposit. This is one of the most severe offenses a licensee can commit and almost always leads to the permanent revocation of a real estate license. Good record-keeping practices are the only defense against accusations of such unethical behavior. Disputes over earnest money arise when the buyer and seller cannot agree on who is entitled to the funds after a failed transaction. When a broker receives conflicting demands for the return or forfeiture of the deposit, they must notify the Florida Real Estate Commission within 15 business days. Once this notification occurs, the broker must then initiate one of the 4 statutory settlement procedures to resolve the dispute. The first is mediation, which is a non-binding negotiation where a neutral third party helps the disputing sides reach a voluntary settlement. The second is arbitration, where the parties allow a third-party arbitrator to hear their arguments and reach a binding decision. The third is litigation, specifically an interpleader lawsuit, where the broker deposits the funds with the court and allows a judge to determine their distribution. Finally, the broker can request an escrow disbursement order from the FREC, though this is only possible if the dispute is clearly within the Commission's scope of authority. There's also a nuanced situation known as good faith doubt. This occurs when a broker has a reasonable belief that neither party has a clear claim to the funds, or perhaps one party refuses to communicate at all. If a broker encounters such uncertainty regarding the disposition of the escrow funds, they must notify the Commission within the same 15-day window. If the broker is holding funds and one party simply fails to provide instructions while the other party remains silent, the broker must proceed with caution. The key here is that the broker must act in good faith and demonstrate that they have made a reasonable attempt to contact the parties. Following these prescribed legal channels removes potential liability from the broker and shifts the burden of resolution to the appropriate judicial or administrative authorities. Always document every step of this notification process to provide evidence of compliance during a later audit. I will see you in the next lecture. Welcome back. Let's begin our deep dive into the complex world of real estate contracts and the specific legal forms governing Florida transactions. To understand the enforceability of any agreement in Florida, you must first master the essential elements known by the mnemonic colic. Starting with competent parties, all individuals involved must be of legal age and sound mind to enter into a binding agreement. Offer and acceptance signify a meeting of the minds where both parties agree to the specific terms set forth in the deal. The legal objective requirement ensures that contracts for illegal activities are deemed invalid from the start, as courts will not enforce terms that violate the law. The statute of frauds mandates that any contract for the transfer of an interest in real property must be in writing to be enforceable. Finally, consideration refers to the value exchange between parties, which does not necessarily have to be money but can include promises or mutual performance. Without these 5 elements, a contract lacks the structural integrity required to stand up under judicial scrutiny during a dispute. Each of these components serves as a safeguard, ensuring that the agreement is based on mutual, transparent, and legal consent. By focusing on these core requirements, you remove ambiguity when analyzing whether a transaction is built on a solid foundation. Beyond the basic elements, you must grasp the distinction between various categories of legal agreements. A bilateral contract involves a promise for a promise, where both parties have mutual obligations to perform, such as a standard purchase agreement. Conversely, a unilateral contract involves a promise in exchange for performance, meaning only one party is obligated to act until the other completes a specific task. Furthermore, you must understand the difference between void and voidable contracts, as this frequently appears on state examinations. A void contract is inherently unenforceable because it fails to meet legal requirements, whereas a voidable contract may be rescinded by one of the parties due to factors like duress or misrepresentation. We also look at the statute of limitations, which establishes the time frame for filing lawsuits regarding contract breaches. In Florida, an action based on a written contract must be brought within 5 years, while an oral agreement has a shorter window of 4 years. These distinctions are critical for managing risk and advising clients on the enforceability of their specific contractual arrangements. In the daily practice of real estate, you will rely heavily on established standardized forms like the Florida Realtors and Florida Bar, or FR/Bar, contract. This document is widely used because it balances the interests of sellers and buyers while mitigating common legal risks through clear, pre-printed language. When drafting these agreements, you must be aware of the necessary disclosures attached as riders or addenda to ensure legal compliance. Specifically, the lead-based paint disclosure is a federal requirement for any property constructed prior to 1978, and failing to provide it can result in significant liability for the licensee. Similarly, the HOA disclosure is mandatory in Florida, requiring the seller to provide a summary of community association rules and fees to the potential buyer. These disclosures are not optional attachments. They're integrated parts of the contract that provide essential material facts. Ignoring these requirements disrupts the flow of the transaction and exposes you to potential disciplinary action from the commission. Listing contracts serve as the service agreement between the seller and the brokerage, yet they come in different forms that significantly impact how you earn your commission. An open listing allows a seller to employ multiple brokers simultaneously, where only the broker who finds the buyer earns the compensation. An exclusive agency listing allows the broker to be the sole representative, but reserves the right for the seller to sell the property themselves without owing a commission. The exclusive right of sale is the most protective for the agent, as the broker earns a commission regardless of who sells the property during the listing period. You must remain particularly cautious regarding net listings, where the seller specifies a desired amount, and the broker keeps everything above that number as profit. While not strictly illegal in all jurisdictions, they are often discouraged in Florida because they create an inherent conflict of interest between the broker's fiduciary duties and their own financial gain. Every listing agreement must be clear on its terms, expiration dates, and the specific duties expected of the real estate professional involved. See you in the next lecture. Welcome to this deep dive into the foundational architecture of real estate law, where we explore the essential concepts of property rights and ownership structures. In this chapter, we will rigorously examine how the law categorizes property and defines the legal interests individuals hold in land. To understand real estate in Florida, we must first distinguish between real property and personal property. Real property includes the land itself, improvements attached to the land, and the bundle of legal rights associated with ownership. Personal property, often called chattels, consists of items that are movable and not permanently affixed to the land. This distinction is vital because the legal transfer of real property requires written documents like deeds, whereas personal property is generally transferred via a bill of sale. When fixtures, items that were once personal property but become attached to real property, are involved, disputes often arise during sales. For exam purposes, remember that the law evaluates intent, method of attachment, and the relationship of the parties to determine if an object has become a fixture. Proper identification ensures that your contracts accurately represent what is included in a transaction, preventing litigation over whether an appliance or light fixture remains with the home. Ownership is defined by a collection of rights, known as the bundle of rights, often remembered by the acronym DEEP-C. These rights include the right of disposition, which allows an owner to sell or transfer property. Enjoyment, which ensures the owner can use the property legally. Exclusion, the right to keep others off the land. Possession, the right to physically occupy the premises. And control, which covers the owner's right to manage the property according to laws. When you possess fee simple title, you hold the maximum interest possible in real estate, allowing for the greatest bundle of rights. Conversely, a life estate ends upon the death of the measuring life, leading to either a reversion to the grantor or a remainder interest to a third party. Leasehold estates, or non-freehold estates, provide a right of possession without ownership, such as an estate for years with a specific termination date or a tenancy at will with no fixed end date. Mastering these distinctions allows you to advise clients on the specific quality of interest they are acquiring or relinquishing. When we talk about co-ownership in Florida, the form of title dictates how property is held during life and transferred upon death. A tenancy in common is the default form of ownership for multiple owners, where each party holds an undivided interest and may pass their share to heirs. Joint tenancy features the right of survivorship, meaning the interest of a deceased owner automatically passes to the remaining survivors rather than to heirs. To create a joint tenancy, the four unities of possession, interest, time, and title must be present at the time of inception. Tenancy by the entireties is reserved exclusively for married couples and also includes the right of survivorship, effectively protecting the property from certain individual debts. Understanding these forms prevents errors in public records and ensures that a client's estate planning goals are aligned with their real estate holdings. You must be precise when instructing buyers on how they wish to take title, as this decision has profound legal and tax implications. Florida provides unique protections under the homestead law, which is designed to preserve the family home from forced sale by creditors. To qualify, the property must be the owner's primary residence, and there are specific limitations on the amount of acreage covered in rural versus municipal settings. This exemption does not protect against tax liens, mortgage foreclosures, or construction liens related to the property. Beyond creditor protection, homestead status offers significant tax benefits, including an exemption from assessed value and capped increases on annual tax assessments. Answering questions in this area requires you to understand the difference between the legal homestead status for creditor protection and the homestead tax exemption. Both are central to the Florida lifestyle and provide tangible financial security to primary homeowners within the state. Finally, we encounter the distinct structures of condominiums and cooperatives, which represent specialized forms of ownership in high-density markets. In a condo, an owner holds a fee-simple title to their unit along with an undivided interest in common areas. You must be familiar with the Florida Condominium Act, which mandates specific disclosures for buyers, such as the declaration, current financial statements, and the FAQ document. Resale units require an additional set of disclosures to ensure the buyer understands the association's governing documents and potential financial obligations. A co-op, by contrast, involves ownership of shares in a corporation that owns the building, accompanied by a proprietary lease for a specific unit. Differentiating between these structures is crucial because the financing requirements, tax implications, and association governing powers shift depending on the specific ownership model chosen by the client. Please proceed to the next session at your convenience. Welcome back. In this chapter, we will master the technicalities of how property ownership is transferred, documented, and defined under Florida law to ensure your success on the state exam. Understanding how title is acquired is fundamental to real estate practice because it dictates the legal validity of an ownership transfer. Voluntary alienation occurs when a grantor transfers property through a deed or a will, reflecting a conscious choice by the owner. Conversely, involuntary alienation happens when the law forces a transfer without the owner's direct consent. Dissent applies when someone dies intestate, meaning they left no valid will, and property passes to their legal heirs according to state statutes. Escheat becomes relevant when an owner dies without a will and has no known heirs, as the property then reverts to the state. Adverse possession is a unique situation where a trespasser gains title through open, notorious, and hostile occupation over a statutory period. Finally, eminent domain allows governmental entities to take private land for public use, provided that just compensation is paid to the owner. The deed serves as the instrument of conveyance, and the level of protection depends heavily on the type of deed utilized. A general warranty deed provides the most comprehensive protection to a buyer, as it includes covenants of season against encumbrances and further assurance. A special warranty deed limits the grantor's liability, warranting only that the title has not been impaired during the time they held it. A quitclaim deed, by contrast, offers the least protection, as it transfers only whatever interest the grantor may have, often used to clear clouds on a property title. Within these instruments, specific clauses define the scope of the transfer. The granting clause indicates the intent to convey. The habendum clause defines the estate being granted, and the redendum clause reserves some part of the estate for the grantor. Recording a deed is not strictly required for validity between parties, but it is essential for providing constructive notice to the public. Constructive notice is the legal presumption that everyone knows about a recorded document, which protects the buyer against future claims of ownership. Without this formal record, a subsequent bona fide purchaser could potentially acquire the property without knowledge of the previous transaction. Legal descriptions must be precise to avoid boundary disputes and ensure that the land conveyed matches the intent of the parties. We use various systems in Florida to identify parcels to prevent overlaps or gaps in ownership. A common method is the METES and bound system, which relies on a point of beginning and physical benchmarks to trace the perimeter of a property. The government survey system provides a more grid-based approach to defining large tracts of land across the state. This system utilizes principal meridians and baselines to define townships, which are 6-mile by 6-mile squares. Each township is divided into 36 sections, and each individual section contains exactly 640 acres. When you need to calculate acreage for a portion of a section, you must remember that an acre consists of 43,560 square feet. Fractional descriptions, such as the northwest quarter of the southeast quarter, require you to work backward through the fractions to determine the total area. For instance, a quarter of a section would be 40 acres, calculated by dividing 640 by 4 and then by 4 again. In urban environments or developed subdivisions, the lot and block system, often referred to as the recorded plat map method, is the standard for description. This system is convenient because it references a map recorded in the public records of the county, identifying specific lots within a block. When a developer creates a subdivision, they record this plat to show the exact dimensions and locations of all individual parcels. For the exam, recognize that this method is typically used in residential and commercial developments, while the government survey and METES and bound systems are more common for larger or rural land parcels. Always ensure you are familiar with the conversion factors regarding square footage and acreage, as these small details often appear in the quantitative portion of the state test. Consistently applying these rules to your practice problems will significantly increase your accuracy. See you in the next lecture. Welcome to our exploration of environmental hazards and the regulatory landscape governing land use in Florida. This chapter provides the essential knowledge you need to navigate how environmental factors and zoning laws dictate what can be built, where it can be placed, and how land is ultimately managed. In Florida, environmental hazards present unique challenges that every licensee must understand to provide competent representation. Perhaps the most prominent concern is the prevalence of sinkholes, which occur as soluble rock like limestone dissolves under the surface, creating potential foundational instability. We must also consider the stringent regulations governed by coastal construction control lines, which dictate the specific setbacks and building design requirements intended to protect the state's sensitive beach and dune systems from erosion and storm surges. Another area requiring professional vigilance is the documentation regarding historical contamination, particularly from dry cleaners, which often necessitates environmental site assessments during the due diligence phase of a commercial transaction. These issues are not merely technical administrative hurdles, but represent significant liability concerns that can fundamentally alter the marketability and insurability of property. By mastering these environmental variables, you move beyond simple salesmanship to become a true advisor capable of identifying potential red flags before they become costly contractual failures. Land use planning in Florida functions as a hierarchical system designed to ensure orderly growth, primarily driven by the Growth Management Act. This legislation mandates a comprehensive plan for every county and municipality, ensuring that development does not outpace the availability of public services, a requirement formally known as concurrency. Concurrency requires that basic infrastructure, such as sanitary sewer, potable water, drainage, and solid waste disposal systems must be available at the time of development. Within these communities, local governments utilize zoning ordinances to divide land into specific categories, including residential, commercial, industrial, agricultural, and special use districts. Each classification carries distinct rules regarding density, intensity of use, and setback requirements that an agent must verify against the client's intended use. When a proposed project does not strictly align with a local zoning ordinance, developers may seek a variance to provide relief from strict dimensional standards or a special exception to authorize a specific, predefined use within an existing zone. Understanding the complexities of non-conforming use is helpful for evaluating older properties that were built before current zoning laws were enacted. Often referred to as grandfathering, these properties are allowed to persist in their current state as long as the use remains consistent and has not been abandoned. However, major structural changes or a change in the classification of use can jeopardize this status, forcing the owner to pull the property into full compliance with contemporary codes. The Planning Commission acts as the primary body overseeing these land use decisions, serving as the gatekeeper for development interests and community standards. Their recommendations are vital to the local governing body, which makes the final legislative act regarding zoning changes and comprehensive plan amendments. Building codes supplement these efforts by establishing the technical standards for construction, while local health departments exercise direct authority over the approval and maintenance of septic systems. National and state-level mandates play a crucial role in shaping land development, particularly through the Clean Air Act and the Clean Water Act. These federal statutes provide the framework for protecting Florida's delicate wetlands and waterways, which are often the primary targets for new large-scale residential or commercial developments. Developers must obtain the necessary environmental permits, often demonstrating that they have mitigated the impact on local air quality and water runoff patterns. Failure to comply with these acts results in significant legal exposure and can halt or entirely vacate development projects. Furthermore, your responsibilities as a licensee include ensuring that your clients receive proper disclosures regarding flood zones and FEMA flood maps, which significantly influence loan underwriting and insurance premiums. While an agent is not expected to be a certified environmental surveyor, knowing how to interpret these federal overlays is a necessary skill for managing consumer expectations and ensuring transparent property disclosures. See you in our next session. Welcome back. In this chapter, we will examine the mechanics of real estate finance in Florida and the specific instruments that govern lending. Understanding how property is financed is not just about crunching numbers, but about knowing the legal backbone of every transaction. Florida operates as a lien theory state, which means the borrower holds the title to the property throughout the life of the loan. In contrast to title theory states where the lender retains legal title, a Florida borrower grants the lender a lien, meaning the lender has a legal claim to the property as security for the debt. This distinction is vital when considering the foreclosure process, as lien theory states generally require a judicial foreclosure process. For your professional practice, this means you must emphasize to clients that they are the legal owners of the home from the moment the deed is recorded, provided they fulfill their obligations under the promissory note and mortgage. The promissory note serves as the financing instrument, essentially the borrower's personal IOU, which details the interest rate, payment schedule, and terms of repayment. The mortgage instrument itself is the security instrument that pledges the property as collateral, linking the borrower's promise to pay with the actual lien recorded against the real estate. Within these documents, specific clauses dictate the rights and obligations of both parties, each carrying significant weight during the lifetime of a loan. The acceleration clause is perhaps the most critical for the lender, as it permits them to demand the entire remaining balance of the loan immediately upon a borrower's default. Conversely, the alienation clause, often referred to as a due on sale clause, restricts the transfer of ownership by requiring the balance to be paid in full if the property is sold without the lender's prior written approval. When a loan is finally paid in full, the defeasance clause comes into play, requiring the lender to remove the lien, providing the borrower with clear and unencumbered title. Finally, the prepayment clause outlines the terms under which a borrower may pay off a loan early. Some loans include penalties for such actions, while others allow for early payment without additional costs. Mastering these clauses is necessary because they directly impact a borrower's flexibility and a lender's risk profile during the life of a loan. Beyond the mechanics of the contract, you must understand the financial metrics like loan-to-value ratios and the role of the secondary market. The LTV ratio represents the percentage of the property's appraised value that is financed by the loan, and it is a primary indicator of risk for any lender. When interest rates or loan terms are adjusted, lenders may use discount points to increase their yield, where each point typically costs 1% of the loan amount and reduces the interest rate by a fraction. These loans often originate in the primary market, but they are frequently bundled and sold to the secondary market participants like Fannie Mae, Freddie Mac, and Ginnie Mae. This secondary market activity provides liquidity to the entire financial system, allowing lenders to free up capital to issue new loans to subsequent borrowers. While primary lenders interact directly with consumers, it is the secondary market's appetite for these mortgage-backed securities that ultimately dictates the availability and cost of capital for your real estate clients. Different loan products serve unique borrower demographics, and you must distinguish between conventional financing and government-backed programs. Conventional loans are not insured or guaranteed by the federal government, often requiring private mortgage insurance if the LTV exceeds 80% to protect the lender. On the other hand, the Federal Housing Administration insures FHA loans to reduce risk for lenders, while the Department of Veterans Affairs guarantees a portion of VA loans for eligible service members. It is a common point of confusion to conflate mortgage insurance, but remember that PMI applies to conventional loans, while the mortgage insurance premium is specific to FHA products. Understanding whether a borrower needs a low down payment FHA loan or a zero down payment VA loan is a functional skill that elevates your value as a consultant. You will also encounter amortized loans, which pay down principal over time, compared to balloon payment structures where a large final payment is due after a period of lower installments. Finally, we must consider the macroeconomic influence of the Federal Reserve and the variety of interest structures available to modern borrowers. The Federal Reserve manages the money supply and influences interest rates, which indirectly dictates the baseline cost of borrowing for the entire real estate industry. When the Fed increases rates, the cost of debt rises, which can cool down property demand, whereas lower rates generally stimulate market activity. Within this environment, adjustable rate mortgages, or ARMs, offer an alternative to fixed rates, featuring interest rates that fluctuate based on a specific economic index and a set margin. These instruments include periodic caps and lifetime caps to protect borrowers from extreme volatility, though the complexity of these resets requires clear communication between you and your client. By grounding your knowledge in these concepts, you shift from simply facilitating a transaction to providing high-level financial guidance. I will see you in the next lecture. Welcome back, everyone. Today we are examining the mechanics of property valuation and the principles that drive real estate appraisal. In the world of professional real estate, understanding value is not merely about guessing a number, but about applying rigorous methodologies that stand up to scrutiny. We must first distinguish between price, cost, and market value, as these terms are frequently conflated by laypeople but carry distinct meanings in a legal or appraisal context. Price is the actual amount of money paid for a property, while cost represents the total dollar expenditure required to bring a structure into existence, including labor and materials. Market value, however, is a theoretical construct representing the most probable selling price in an arm's length transaction between a knowledgeable buyer and seller. For value to exist as a measurable quantity, the property must possess four specific characteristics commonly acronymized as DUST. Demand represents the level of desire for a property, while utility refers to its ability to satisfy human needs or desires. Scarcity acknowledges that supply must be limited to create value, and transferability ensures that legal ownership can be passed from one party to another without insurmountable hurdles. When deep diving into the valuation process, professionals rely on several fundamental principles that govern how markets react to real estate. The principle of substitution is perhaps the most significant, positing that an informed buyer will pay no more for a property than the cost of acquiring an equally desirable substitute. We also consider the highest and best use, which defines the use that will produce the greatest net return to the land over time. Additionally, the principle of increasing and decreasing returns reminds us that improvements to a property will only increase value to a certain point, after which the cost of the improvement will not be fully recovered. To quantify these values, we utilize three distinct approaches: the sales comparison approach for residential properties, the cost appreciation approach for unique, special-purpose structures, and the income capitalization approach for properties designed to generate ongoing revenue. It is vital to recognize that a broker price opinion or a comparative market analysis, while useful for listing purposes, are not formal appraisals and must be explicitly distinguished from those products in your professional practice. The sales comparison approach heavily relies on our ability to objectively adjust comparable properties to the subject property through a standardized logic. We use the acronym CBS to remember that if the comparable is better, we must subtract from its selling price to arrive at an adjusted figure. Conversely, if the comparable is inferior, we utilize the CIA method, which dictates that we must add value to the comparable to bring it into parity with our subject. When we utilize the cost appreciation approach, we must account for the loss in value from three specific sources of obsolescence. Physical deterioration covers the normal wear and tear of a structure, such as a leaking roof or aging foundation, while functional obsolescence involves issues like an outdated efficient layout or lack of modern amenities. External or economic obsolescence is the most difficult to cure, as it stems from factors outside the property lines, such as a nearby industrial plant or a plummeting local economy that decreases desirability. See you in our next session. Welcome back. Today we transition into the sophisticated world of investment analysis and property management to round out your mastery of Florida real estate principles. In this chapter, we will explore the fundamental metrics of real estate investing and the regulations governing professional property management in Florida. By the end, you will possess the analytical toolkit required to evaluate property performance and the legal clarity to manage rental operations in total compliance with Chapter 83. Real estate is often viewed as a superior investment vehicle because of its unique properties regarding leverage and tangible value. When we talk about leverage, we are referring to the use of borrowed capital to increase the potential return on an investment. While leverage can magnify gains, it also increases the inherent risk, as the debt service must be paid regardless of the property's income stream. Another critical consideration is liquidity, or the ease with which an asset can be converted into cash without significant loss of value. Real estate is inherently illiquid compared to stocks or bonds because of the lengthy transaction process and the physical nature of the asset. Investors must also account for business risk, financial risk, and purchasing power risk when constructing their portfolios. Successfully navigating these factors requires a deep understanding of how internal revenue streams are calculated and how external market forces impact these valuations. To determine if a property is performing as expected, we often rely on the net operating income, or NOI. To derive this figure, you take the potential gross income, add any other income sources, and subtract vacancy losses to reach the effective gross income. From there, You deduct operating expenses, such as maintenance and taxes, but you must be careful to exclude mortgage debt service and income taxes from this calculation. Once you have the NOI, you can use the IRV formula where income equals the rate times the value. By rearranging this, you can find the capitalization rate by dividing the NOI by the property value. A higher cap rate generally implies higher risk or lower property value, while a lower cap rate indicates a more stable, higher valued asset. Investors also use the operating expense ratio, calculated by dividing operating expenses by the effective gross income, to gauge how much of the income is being consumed by day-to-day operations. When investors desire a more granular look at their actual cash flow, they turn to the cash-on-cash return. This metric calculates the ratio of the annual before-tax cash flow to the total amount of cash invested in the property. Unlike the cap rate, which ignores financing, this return is highly sensitive to the mortgage terms and the actual out-of-pocket investment. In the commercial sector, these cash flows are governed by specific lease structures that allocate risk between the landlord and the tenant. A gross lease generally requires the landlord to pay all operating expenses, while a net lease shifts the burden of taxes, insurance, or maintenance to the tenant. Percentage leases are common in retail settings, where rent is based on a percentage of the tenant's gross sales. Finally, variable or index leases use a base index, such as the Consumer Price Index, to adjust rent payments over time as economic conditions fluctuate. Property management is a specialized field that necessitates strict adherence to Chapter 475 of the Florida Statutes. If you provide property management services for others for compensation, you must hold an active real estate license under a broker. The scope of your duties as a property manager involves acting as a fiduciary for the property owner while maintaining the physical asset and managing tenant relations. This includes screening prospective tenants to ensure creditworthiness, enforcing the terms of the lease agreement, and executing rent collection protocols. Maintenance is equally critical, as keeping the property in good repair is essential for asset appreciation and legal compliance. You are the operational bridge between the owner's financial goals and the day-to-day reality of the physical site, necessitating constant communication and record-keeping skills. The Florida Residential Landlord and Tenant Act, found in Chapter 83, provides the legal framework for all residential leasing activities. A major area of focus for the state exam is the handling of security deposits, which are strictly regulated to protect both parties. If you intend to impose a claim on a security deposit, you must send written notice to the tenant via certified mail within 30 days of the tenant vacating the premises. If you do not intend to make a claim, you must return the deposit back to the tenant within 15 days. Failure to provide these notices within the statutorily mandated timeframes can lead to the forfeiture of your right to claim any portion of those funds. These timelines are absolute, and as a licensee, you must manage these deadlines with the same urgency as any other trust fund obligation. Eviction is the final, unfortunate step in property management that follows a strictly defined legal process. If a tenant fails to pay rent, the landlord must first provide a formal 3-day notice to pay rent or vacate the premises. This window gives the tenant a final opportunity to cure the default before legal proceedings commence in county court. If the tenant remains beyond this period without paying, a lawsuit for possession may be filed. For lease violations other than non-payment, a 7-day notice of noncompliance is required to provide the tenant with an opportunity to correct the issue or face termination. These procedures are designed to ensure due process and must be navigated carefully to avoid unlawful actions that could result in significant liability for the landlord. I will see you in the next lecture. Welcome back. Today, we are starting a critical chapter on the closing process and the complex regulatory framework governing real estate transactions. We will master the TRID rules, focus on closing documentation, and learn how to handle financial proration efficiently. The closing process is the culmination of every real estate transaction, where legal title finally shifts from seller to buyer under the watchful eye of a closing agent. In Florida, this agent, often a title company or an attorney, serves as the neutral third party who disburses funds and ensures that all contractual obligations are met. The TILA-RESPA integrated disclosure, commonly known as TRID, was enacted to simplify these disclosures and prevent the information asymmetry that once plagued consumers. Under the oversight of the Consumer Financial Protection Bureau, lenders must provide a loan estimate within 3 business days of receiving a loan application. This document serves as a blueprint for the expected costs, while the closing disclosure provides a final, detailed accounting of every dollar involved in the sale. You must remember that the closing disclosure must be delivered to the borrower at least 3 business days before the actual closing. If this window is violated, the closing must be delayed to ensure the consumer has adequate time to review the financial terms. One of the most persistent issues in real estate law is the improper exchange of compensation between service providers, which is strictly prohibited under Section 8 of the Real Estate Settlement Procedures Act. RESPA prohibits kickbacks, fee splitting, or any unearned fees for referrals in connection with a federally related mortgage loan. As a licensee, you must understand that if you recommend a settlement service provider, you cannot accept a commission or rebate in exchange for that referral. This regulation is designed to keep the playing field level and ensure that consumers are not steered toward providers who prioritize kickbacks over competitive pricing. Violation of these provisions can lead to significant federal penalties, including criminal prosecution and civil liability. Always maintain transparency with your clients and disclose any business relationships you may have with service providers. Professional integrity is not just an ethical requirement. It is a legal mandate that protects both you and the public interest. Financial accuracy during a closing relies heavily on the correct calculation of prorations, which divide expenses between the buyer and seller based on the time each party owned the property. We typically use either a 360-day year, often called the statutory year, or a 365-day year, known as the actual calendar year, to determine these daily rates. Property taxes are almost always paid in arrears, meaning the seller typically owes the buyer a credit for the period before the closing date. You will often calculate rent, interest on assumed mortgages, and prepaid insurance premiums in a similar fashion. Remember that a credit to the buyer is a debit to the seller, and vice versa, depending on who prepaid or who is responsible for the accrual. Practice these calculations until they become instinctual, as you will certainly encounter them on the state examination. Accurate math ensures that neither party is unjustly enriched or burdened at the table. Before the final signatures are applied, the buyer is entitled to conduct a final walkthrough to confirm that the property condition matches the terms of the purchase contract. This is not a chance to renegotiate, but rather a verification that any agreed-upon repairs were completed and that no new damage has occurred since the inspection period. Simultaneously, the closing agent ensures that the title is clear of liens or encumbrances, that the deed is prepared, and that all recording fees are accounted for. Buyers usually pay for recording the deed and mortgage, while sellers often bear the cost of satisfying existing liens or clearing defects in the title. By meticulously satisfying these contingencies, you ensure a smooth transfer of ownership and satisfy your fiduciary duty to your client. Preparing your clients for these technical steps is a testament to your professionalism and competency as a Florida licensee. See you in the next lecture. Welcome back to the course, where we turn our focus to the fiscal mechanics of real estate transactions in Florida. In this session, we will dissect the specific state taxes and proration methods essential for accurate closing statements. Understanding Florida's state taxes is a matter of precision, as the statutes identify 2 specific types of documentary stamp taxes. When a deed is transferred, The seller is typically responsible for the documentary stamp tax on the deed, which is calculated at a rate of 70 cents for every $100 of the total consideration paid. For example, if a property sells for $200,000, you divide that amount by 100 to get 2,000 units, then multiply by 70 cents to arrive at a total tax of $1,400. In addition to the deed tax, new promissory notes are subject to a documentary stamp tax of 35 cents per $100 of the debt amount. Furthermore, the state imposes an intangible tax on new mortgages at a rate of $0.002 per $1 of the new loan amount. These costs are often treated as distinct line items on a closing disclosure, and miscalculating them can lead to significant friction when balancing the final figures. It is helpful to view these as deterministic rules rather than negotiable points. The state mandates these, and your role as a professional is to apply the math consistently. By mastering these coefficients, you ensure that the financial narrative of the transaction remains compliant with Florida law. Property taxation in Florida follows a rigid calendar designed to keep local government functions moving smoothly. The cycle effectively begins on January 1st, which is the official lien date, marking the moment when the property tax liability attaches to the real estate for the year. Taxes become payable on November 1st, and the law provides a discount schedule for early payments made in November, December, January, or February. If those taxes remain unpaid after March 31st, they become delinquent on April 1st, at which point interest and penalty fees begin to accumulate. As part of this process, homeowners receive a trim notice, or truth in millage notice, which informs them of the proposed tax rates and the assessed value of their property before the final tax bill is issued. This notice acts as a vital communication bridge between the taxing authority and the owner, providing a window for the taxpayer to appeal the assessed value if it seems out of alignment with fair market values. Remember that ad valorem taxes represent the value-based component of this system, meaning the tax amount is calculated by applying the millage rate to the taxable value of the property. The Save Our Homes Amendment provides a critical layer of protection for permanent residents against skyrocketing property tax increases. This amendment caps the annual increase in the assessed value of a homesteaded property at 3%, or the percentage change in the Consumer Price Index, whichever is less. Because the market value of a home can rise far more rapidly than this capped assessed value, the disparity creates a tangible tax savings benefit that can be substantial over a decade of ownership. When a property is sold, however, that cap is reset based on current market values, and the process begins again for the new owner. Beyond these standard levies, you must also be capable of identifying special assessments, which are specific charges levied against properties for local capital improvements like sidewalks, sewer lines, or street lighting. These are treated differently from general property taxes, as they are typically tied to the identifiable benefit provided to the specific parcel of land. Navigating these assessments requires a clear understanding of the difference between an ongoing tax obligation and a one-time improvement cost. Prorating expenses at closing requires a standardized approach to dividing annual costs based on the duration of ownership. The formula for any prorated item is simply the annual amount paid divided by 365 days of the year, multiplied by the number of days the party is responsible for that expense. For a typical closing, you look to the sales contract to determine whether the day of closing itself is assigned to the buyer or the seller. In most standard residential contracts, the day of closing is effectively the buyer's day, meaning the buyer is responsible for all costs and income accruing from the moment the deal settles. When you calculate the proration, you must exercise extreme care in counting the days, as even a one-day discrepancy will throw off the final settlement statement. Always verify the specific contract terms before performing the math, because custom contracts can occasionally deviate from standard practices. By treating prorations as a purely arithmetic exercise, you reduce the risk of emotional conflict between the parties, allowing the closing process to proceed with the objective clarity that professionalism demands. See you in the next lecture. Welcome back. Let's examine the economic forces that dictate the flow of capital and inventory within the Florida real estate landscape. In this chapter, we focus on identifying the specific variables that cause market fluctuations and how to interpret these trends for professional practice. To understand the macro environment of Florida real estate, we must first look at the factors influencing supply. At its most fundamental level, supply in this industry is constrained by tangible inputs, such as the availability of skilled labor, the fluctuating cost of raw construction materials, and the geographic limitations of land availability. Beyond these physical constraints, government policy plays a decisive role through zoning ordinances that dictate use and tax structures that influence development profitability. When taxes on development increase or municipal zoning becomes more restrictive, the lead time for new inventory expands, thereby limiting the current supply. Similarly, the availability of land is not just a spatial issue, but a regulatory one, as environmental protections and urban growth boundaries define where developers can even begin to conceptualize a project. A real estate professional must track these variables because they dictate the pipeline of future housing and commercial space. If labor costs rise while zoning remains tight, the predictable outcome is a constrained supply regardless of how high underlying demand might be. Conversely, the demand side is driven by a different set of variables that act as predictors for transaction volume. Population growth, particularly here in Florida, remains the primary catalyst for demand, fueled significantly by retiree migration and international interest. When we analyze demand, we also evaluate local income levels and how those incomes correlate with current housing costs. Consumer preferences shift over time, and in a post-pandemic market, these preferences have swung towards specific lifestyle amenities and remote work capabilities. Meanwhile, mortgage credit availability serves as the primary gateway for buyer participation. When lending standards tighten, the buyer pool shrinks, regardless of how many people wish to move to the state. We also see that these factors do not act in isolation, as high population growth without corresponding mortgage credit will still result in lower transaction volume. Understanding this equilibrium is necessary for any licensee acting as an advisor to clients. The Florida market is deeply sensitive to specific economic indicators like tourism and its distinct pattern of retiree migration. Tourism acts as an economic base, supporting service sector employment and indirectly sustaining the housing market in high-traffic coastal areas. When tourism is robust, the local economy expands, increasing the tax base and funding the infrastructure that makes an area desirable for permanent residents. Retiree migration, however, provides a different set of pressures, typically increasing demand for residential inventory that offers specific geographic and lifestyle features. These factors directly influence real estate values because they dictate the long-term desirability of specific Florida counties. A professional must be able to synthesize how a slowdown in tourism or a shift in migration patterns might signal an upcoming correction in regional property values. We must also consider the role of vacant land and the mechanics of subdivision development as indicators of market health. The development of raw land into a subdivision follows a cyclical path from acquisition to entitlement to horizontal construction. You should monitor the absorption rate, which is the speed at which available homes are sold in a given market area within a specific time period. A low absorption rate suggests that the market is oversupplied or that demand has stalled, while a high rate indicates a seller's market where inventory is depleting rapidly. By analyzing the inventory of vacant land, you can often predict where future development will shift and how that might impact existing home values in surrounding neighborhoods. This granular level of analysis distinguishes a professional who understands market mechanics from one who simply tracks current listing prices. When looking at commercial opportunities, particularly in business brokerage, we encounter the concepts of going concern value and goodwill. A business that is already in operation, with an established structure, staff, and customer base, carries an intangible value known as goodwill. Going concern value refers to the property as a functioning, profitable entity rather than just a collection of assets like real estate and equipment. When these assets are sold together, the total value is often higher than the sum of the individual parts because the buyer is purchasing a proven revenue stream. As a licensee, you must differentiate between the value of the physical real estate and the value of the business operations hosted within it. This distinction is critical for accurate pricing and for ensuring that the client understands whether the purchase price includes enterprise operations or just physical assets. Lastly, interest rate fluctuations serve as the most immediate lever affecting buyer purchasing power. A change in interest rates of even a single percentage point can drastically alter the monthly debt service for a borrower, effectively removing individuals from the market or increasing their buying power. In the Florida market, this manifests as a direct change in transaction volume and price appreciation rates. Higher interest rates typically lead to a cooling of the market as financing becomes more expensive and fewer buyers can qualify for loans. A market-savvy agent monitors Federal Reserve announcements and bond yields to anticipate these shifts rather than reacting to them after they have already stalled transactions. By watching these economic signals, you can provide far more value to your clients by guiding them through timing and strategy based on macroeconomic reality. Catch you in the next lecture. Welcome to the final review of our course where we consolidate everything you need to successfully navigate the Florida State examination. We will synthesize the core curriculum and finalize your preparation strategy. To succeed on the Florida State exam, you must recognize that it is not merely a test of memory, but a test of application regarding Florida Real Estate Commission rules. We have previously covered the granular details, but now we must focus on the high-weight domains that consistently appear in the 100-question pool. Brokerage relationships remain the highest priority, requiring you to distinguish clearly between transaction brokerage, single agency, and no brokerage relationships. You must be able to identify which fiduciary or limited duties apply in every scenario presented in a question. License law and the authority of the FREC often appear as administrative questions, so ensure you understand the difference between ministerial duties and quasi-judicial powers. Furthermore, property disclosures, particularly regarding lead-based paint and material defects, are factual mandates that require rote memorization. If you can master these three pillars, brokerage relationships, license law, and property disclosures, you have already secured a significant percentage of the points needed for the 75% passing threshold. When we shift our focus to the computational side of the exam, the T-bar method is our most robust tool for maintaining accuracy under pressure. For commission calculations, remember that the commission amount divided by the sale price equals the commission rate, and any variation of this T-bar allows you to solve for the missing variable instantly. Prorations are more complex, but the logic remains consistent if you designate who owes whom at the closing table for items like property taxes or prepaid rents. Always confirm whether the tax year is paid in arrears and determine if the proration is based on a 365-day year or a 360-day year as specified in the question. When calculating state documentary stamp taxes on deeds, promissory notes, and intangible taxes, do not attempt to memorize every single rate, but practice the division rules until they are second nature. The objective is to identify the base amount and apply the tax rate correctly, acknowledging that these questions are designed to test your attention to detail rather than advanced mathematical capability. Exam day strategy is just as crucial as content knowledge, starting with your approach to the 100 questions. You have limited time, so if you encounter a complex math problem that stalls your momentum, mark it, skip it, and return later. Every correct answer contributes equally to your 75% goal, meaning it is irrational to spend 10 minutes on a difficult calculation when there are simple law questions waiting for your attention. As you analyze multiple choice options, practice the process of elimination to remove the clearly incorrect distractors first. Usually, 2 of the 4 answers are obviously wrong, which significantly improves your probability of selecting the right response. Managing your mindset is professional. Treat the exam as a business process where you identify the requirement, isolate the relevant legal rule, and select the answer that conforms to Florida law. Preparation for the actual test center environment is an often overlooked aspect of the process. You must arrive early with your valid government-issued identification, ensuring it matches your application information exactly, because discrepancies here will result in you being denied entry. Review the test center policies regarding permissible calculators before you enter the building, as you are usually restricted to specific, simple, non-programmable models. Once you are seated, take a moment to regulate your breathing before the clock starts, as the first few minutes set the pace for your performance. Keep track of your pacing relative to the total time allowed to ensure you do not leave any questions blank, as an unanswered question is mathematically identical to an incorrect one. Maintaining a focused state of mind is your final responsibility before you submit your exam for grading. After you pass, your professional life begins with the activation of your license through a sponsoring broker. You should research firms that offer the kind of mentorship or environment that aligns with your specific career goals in real estate. Once you secure a position, your broker will file the necessary documentation with the DBPR to make your license active and official. Do not view the exam as the culmination of your learning, but rather as the baseline requirement for starting your practice. The post-licensing period is when you will transition the theoretical knowledge you gained in this course into practical, revenue-generating activities. Stay committed to professional development, as the market is fluid and success depends on your ability to apply current laws to real-world transactions. Study the material carefully and see you on exam day.